Be seated, please. All right, now we proceed on to count, I believe it's 13 of the indictment. The interesting question is the jury was sworn as to other counts, but I'm not sure that they have actually been sworn as to, we swear them in as to each count on the last oath of the actual juror oath that they take. Actual oath says a true verdict gives. So I'm not. Does either side have any? That's the count. I think just to be on the safe side, Mr. Goff, do y'all wish to? I guess interestingly, whether or not y'all participate in this section of the, since your client is not involved in this last section of this trial. Do you wish?
As much as we enjoy being before Your Honor, since our client has no further business before the court in this phase of the trial, why we would remain I don't know why we would remain in it, Your Honor. However, before we exit the courtroom, we would, on behalf of Mr. Elkins, ask for an appeal bond.
That's denied. But I do want to ask on the record, I did need to get on the record because we did change venue. And so before I excuse counsel for DeMarquis Elkins, I do want you to consult with your client and say whether or not on the record you will agree to, because for appellate purposes, this case actually under the law stays here in Cobb County, unless all counsel agrees to transfer it back to Glenn County. And as far as sentencing goes, did you want to? We still have sentencing to do. Do we want to proceed on with sentencing, or do we need to? Do we want to have that at a later date?
Your Honor, we would ask that sentencing be held at a later date. We need time to complete investigation and preparation for the sentencing hearing in this case. We do have a concern on the venue. We don't object to non-jury proceedings being held in Glenn County. The question is, if and when Mr. Elkins' motion for new trial is granted, or the appeals courts were to grant Mr. Elkins a new trial, and it was time to try the case again, would we be forfeiting our right to the change of venue, and would we be forfeiting our right to this venue by consenting to the return of the case to Glenn County for non-jury matters? Is there any question under the law about that? What I'm going to ask the court to consider is giving us an opportunity to take a look at that.
Absolutely.
Perhaps this afternoon before responding.
Oh well, I think I can address that issue. Obviously, if you consent to move the case back to Glenn County for purposes of non-jury matters, which would be sentencing and appellate motion for new trial issues, I would think, and then of course he were granted a new trial either by this court or appellate court, then and we came back, then you would still have all your previous motions, would still be in effect, including the change of venue, unless you withdrew it or or something of that nature. So.
Well, Your Honor, we just want to make sure on the record that we wouldn't be waiving our right to this venue on retrial.
I don't think it's constitutional in this sense. Unless the state has any objection, I'm going to say that you're not waiving your right to a future change of venue in case of any proceeding. That's the court's interpretation right now. And so as long as I'm the judge on this, I mean, it seems that the state have any thoughts on that matter? No?
We would agree with the court on that.
Okay. Everybody seems to be agreeing. So now you want to take a minute, have you talked with your client about this, having sentencing transfer back to Glenn County?
What we can do, Your Honor, is we can confer with him perhaps while you're proceeding on with the other portion of the case.
Okay. But I do want to get on the record before we leave here today.
Yes, Your Honor.
Because exceedingly important how we proceed.
Your Honor, I would agree.
Okay. All right. We'll be in recess for about, do y'all have a copy of do y'all plan on presenting further evidence?
No, we do have a certified copy of the conviction on count 13 with, and I'm not sure if Mr. McElvain's had an opportunity to look at it. He may have an issue.
there's a sentencing
Karen
sheet,
Mead.
sentencing sheet, but there's no entry of the plea and there's no arraignment. Arraignment cannot be waived. All the state has provided.
I believe arraignment is waived if it's not raised prior to entry of a guilty plea or the verdict of a jury.
There's no proof that the plea was entered.
But she has to have been represented by counsel, and
Karen Mead is her attorney.
There's a plea petition that the state has in their possession, but they do not possess any transcript of the proceedings.
can I see the court see it?
Yes, sir.
Can we mark this as, for purposes of this, as State's Exhibit 1?
Yes.
I think I'm sure.
The court look at it.
This is another issue, Your Honor. The jury wasn't sworn for this charge at the time of presentation of the other.
That's what I mentioned earlier. I think we'd have to swear them.
Well, not only that, but they have to be sworn during the presentation of the evidence. And the state has to recall the witnesses if they want to get into this on that. They weren't sworn as to that charge at the time the evidence was stated.
The law allows them on this type of bifurcated proceeding to re-tender all the evidence that was submitted earlier. But I am concerned as to a plea petition is not the same as a guilty plea.
Your Honor, if you look at the last page of State's Exhibit 1, there's an order that has been entered by the court, signed by Judge Williams, and then an order that has been entered by the court, which is essentially the judgment and sentence of the court. I don't see what more documentation there can be that the court entered a judgment of guilt in the case and adjudicated it guilty and signed it, and the defendant was present. It was represented by counsel. I mean, I don't think you need to have a transcript of a plea to prove that there's an adjudication of guilt in a case.
No, I don't think you do either. I don't think you have to have a transcript, but where she actually entered signing the plea petition, we're missing part of the document here. We're missing where we're missing the portion that where she actually entered her plea of guilty.
Your Honor, the law, once I raised doubt as to the entry of the plea, the court requires the transcript. It can't just travel off of the plea petition itself. It has to see the plea colloquy that the Boykin rights were read and waived, that the client or the defendant entered the plea knowingly and voluntarily, and there just is no record of that in this case. Therefore, they can't.
You have a case that says that?
I have them in my file, but I wasn't ready to go. I thought we'd have a little break, but I can get that to you, Your Honor.
McElvain, may I be allowed to have a moment with my client to discuss the issue you referenced earlier?
Yes, y'all wish. Is there a place outside that they? Okay. Y'all may be excused while we're.
May I see that exhibit again?
You may.
Your Honor, may I, while Mr. McElvain is looking at that, in the documents that we have presented as State's Exhibit 1, there is a plea petition in the case. And then there is an order of the court. The court read and considered the foregoing application, having examined defendant and defendant's counsel in open court concerning same, and it appearing that the allowing of such proposed plea is proper, the court having specifically advised defendants of his rights under Rule 33.8 of the Uniform Rules of the Superior Court, as said rights are set forth in the plea petition, and rights waiver form, the same petition being accepted by this court and entered as part of the official record, it is ordered and adjudged that such waivers are contained in application, as well as such plea of guilty, are freely and voluntarily, intentionally, and so forth entered by defendant. The defendant's entering the plea in the affidavit of counsel, there is a factual basis for the plea of guilty. And then this language, therefore it is further ordered and adjudged that such plea of guilty be allowed and accepted, and that such application in this order be filed and entered with such plea and made a part of the record in this case. Ordered and adjudged 1 October 2008, signed Amanda Williams, Judge Superior Courts, and signed by the defendant. Then there is on that page a final disposition. And it's count 1. It says the finding is signed by the then Chief Judge Judicial Circuit, and there was an order that was entered in 2011.
Hereby waives the copy of the indictment and arraignment, and hereby changes their plea from guilty to not guilty. They sign that, showing that they've actually entered their guilty plea. You may be correct that the signing of the plea petition is sufficient.
I mean, what more?
I'll ask you, we'll take a recess for about 10 minutes, and we'll do a quick...
All right, does the court want to see this while it's making its... Okay, you don't... Well,
Your Honor.
I have an announcement of, yes, Your Honor, we'd be willing to proceed with sentencing and appellate issues in Glenn County.
Your Honor, there's another matter. I understand there are a large number of reporters camped outside the front door of the courthouse. You have an unwritten gag order in effect. Now that the trial is concluded, I assume the gag order has expired.
Gag order has expired. Be careful, though.
Thank you, Your Honor.
Your Honor,
you may be excused. We have recess for about 5 to 10 minutes.
Your Honor, may I go to my car to get...
Yes.
Okay, thank you.